A primer on special needs trusts. First, let's talk about a general background on special needs trusts. Special needs trusts, called SNTs for short, are a specialized form of trust planning that allow individuals with disabilities to qualify for means-tested public benefits, such as medical assistance, also known as MA, Medicaid, or Title 19, and supplemental security income, or SSI. At the same time, the SNTs permit the trust beneficiary to retain assets that would have otherwise made him or her over the asset limits to be eligible for these public benefits. The asset limit is $2,000 for an individual. A SNT can make the difference between a trust beneficiary who can enjoy a private room in a nursing home, take a trip to visit family, hire a trusted family caregiver, purchase a car, take educational courses, and a person with a disability who cannot benefit from these things. A SNT's purpose is to improve the quality of one's life by supplementing basic needs. Let's briefly go over the general characteristics of SNTs, followed by a discussion between the difference of a first and third-party trust. The principle behind a special needs trust is to make the trust assets unavailable to the trust beneficiary with disabilities. This means the beneficiary has no power to direct the use of the trust assets for his or her own support and maintenance. Rather, the authority rests with the trustee, who has absolute and sole discretion in making distribution decisions. By doing so, the assets do not count toward the beneficiary's financial eligibility for public benefits like MA or SSI. Another important and related characteristic of a SNT is that it is irrevocable. Once the trust is created and funded, the assets cannot be returned to the creator, whether the creator is the trust beneficiary or a third party, because if they were, they would be considered an available resource. Distributions from the SNT must be for the beneficiary's sole benefit. The exemption in federal law, which allows SNTs to enjoy this special status of being an exempt asset, requires that the trust be created to benefit the individual and only that individual during his or her life. SNTs are not a tool to transfer wealth to future generations, so grandma cannot use her SNT to make gifts to her grandchildren because the SNT exists for her benefit. The beneficiary must have a disability and show proof of verified disability, whether formal, as determined by Social Security and medical assistance, or informal, as per a physician's letter. Now let's talk about first-party trust, but let's take a moment to clarify trust terms. First-party trusts can also be referred to as self-settled, pooled, or D4C trusts, cited according to the federal statute. For this presentation, we will just refer to first-party trusts. At WisPACT, first-party trusts are known as Trust 1s. Third-party trusts are known simply as third-party trusts, and at WisPACT are known as Trust 2. The source of the assets deposited into a SNT is very important because it will tell us who can set up the trust and whether there will be a payback to the state or not. Whose assets are funding the trust, that is, who owns the assets at the time of creation, will determine if the SNT will be a first or third-party trust. A first-party special needs trust is funded with the trust beneficiary's own assets. The SNT can be created by the beneficiary him or herself, his or her agent, an agent under power of attorney for finances, a representative payee, or court order. Some typical assets used to fund a first-party special needs trust are inheritance made directly to the disabled beneficiary outright, personal injury settlement, maintenance payments in a divorce settlement, workers' compensation award, back payment of public benefits, assets held by the beneficiary at the time of application, and assigned income, such as from a public or state pension fund. A first-party special needs trust can be a viable option in the following situation. Grandma's dementia is progressing and she's becoming more frail day by day. She realizes she can no longer live alone and take care of herself. She requires 24/7 nursing home care. She needs to apply for medical assistance. But first, she needs to spend down her excess assets above $2,000. She cannot just give her money away to family members, as this would also make her ineligible for benefits. However, she could put her excess assets into a SNIT exclusively for her benefit. The SNIT would exempt the assets from being financially countable against her MA eligibility and would allow her to use the money she has saved to improve her quality of life while in the nursing home. For example, she can use the money in her SNIT to pay for a private room. You should also know that a first-party trust may be subject to paying the state back for medical assistance services the person with a disability received after the age of 55. We say may because it depends on the amount of the balance, if any, at death. The rule goes like this. If there is enough balance in the trust account to pay back the state in full for MA services received, then the state is paid back. However, if the funds at death are insufficient to pay the state back in full at 100%, then the funds go into the WisPACT charity fund to be used directly to benefit other trust beneficiaries. People often ask, can my family inherit remaining funds? They can, but it is unlikely. Only after the state is paid back in full does any balance go to the remainder beneficiaries as designated by the primary beneficiary. Third-party trusts. A third-party special needs trust must be funded with assets belonging to anyone other than the beneficiary. Assets that belong to the beneficiary cannot be put into a third-party trust because this would be considered a divestment. At death, it would cause the entire contents of the trust to be treated as first party, thereby triggering a Medicaid payback after the beneficiary has passed away. Here is an example to illustrate the source of funds in a first party versus a third party trust. A contribution by a grandparent in trust for the benefit of a disabled grandchild is a third party trust, whereas an inheritance from a grandparent paid directly to the beneficiary is not a third party trust. If a special needs trust is desired, the beneficiary must create a first-party trust funded with his or her own assets, in this case, the inheritance paid directly to the beneficiary. The creators of a third-party trust can be any third party. Typically, they are parents or grandparents of a child or a grandchild with disabilities, or an agent for a third party can be a creator for a parent. The agent can be a guardian or an agent under a durable power of attorney. A community spouse of a disabled beneficiary can also create a SNIT, but only by will. The SNIT is created and funded upon the death of the community spouse should he or she predecease the disabled spouse. This is called a testamentary trust. Third-party trusts are more flexible than first-party trusts. Third-party trusts can be created as part of an estate plan. For example, a will can create a testamentary trust and authorize the trustee to create and fund a SNIT for the benefit of a disabled child. Or, mom can complete the trust application forms for a disabled daughter now, include the proper language to fund the SNIT in her will or trust, and when the time comes, the special needs trust is funded at the death of the creator. Or mom can create and fund the trust during her lifetime. Usually, there is not the crisis to spend down as in a first-party trust, although if there is, mom can spend down by funding a SNIT for the disabled granddaughter or daughter, and this would not be considered a divestment under medical assistance rules. In terms of distributions from a third-party SNIT, the application of the sole benefit rule is more relaxed than a first party. This is because the assets in the trust were never owned by the beneficiary, who is subject to the rules for public benefits. Therefore, incidental benefits received by a non-beneficiary are acceptable so long as the primary recipient is the WisPACT beneficiary. There are more options with a third-party trust. For income tax planning, the creator of a third-party trust, known as the grantor, may choose to retain a power known as a limited power of appointment, which would allow the grantor to be taxed on interest, dividends, and capital gains earned in the trust subaccount, even if these income sources are retained in the subaccount. This treatment would avoid the highly compressed income tax brackets of a non-grantor complex trust. Lastly, the creator of the trust can authorize that after the creator's death, the trustee can make annual gifts up to 1/3 of the SSI supplement as designated by the beneficiary to certain persons other than the beneficiary. There is no paid-back requirement with a third-party trust. When the beneficiary passes away, the remaining assets may be used to pay for funeral costs and/or distributed to the remainder beneficiaries as named by the creator. In conclusion, we believe that WisPACT is special. A WisPACT Special Needs Trust improves quality of life, protects public benefits, provides an alternative to wasteful spend-downs, and provides fiduciary oversight to prevent financial abuse and exploitation. We serve Wisconsin residents in all counties, no matter the age, income level, or disability. Thank you.